I'd like to thank you all for joining us today, and I will briefly introduce our speakers, and they'll join me at the table. Let me start by introducing Tom Farr, who is a shareholder, a partner at Oaktree Beacons. He has an undergraduate degree from Hillsdale College. He has his Juris Doctor from Emory, and he has an LLM from Georgetown. He is very well known by many of you, I'm sure, for his work as lead counsel in Stevenson v. Bartlett, which is a Supreme Court case in redistricting. And last year he served as counsel to the Speaker of the House and President Pro Tem as they were going through the 2011 redistricting. Tom, if you would join us. Thank you. Also with us is Dr. Stephen Kagan. Steve did his undergrad at Tufts. He has his medical doctorate from the University of Massachusetts. He did his residency at Mass General and a vascular fellowship at the Mayo Clinic. He is board certified as a vascular surgeon, and right now is a principal at Carolina Vascular Surgery and Diagnostics. Dr. Kagan. Now, as Dr. Kagan takes his seat, let me explain to you a little bit about how we're going to do this. Since we're a relatively small group, we can be a little informal. I'm going to ask each of our panelists to share their thoughts for about 5 or 10 minutes on the case and on Obamacare generally. And then we're going to open it up to discussions, or to questions from the audience. And I'll field some of those questions. I'll direct them as appropriate to Tom and Steve. I may ask a few questions of my own. So, without further ado, Tom, if you'd like to kick us off.
Well, lawyers always like to go first. I want you to know that you should be very pleased to know that I'm just like all the congressmen who gave us this wonderful bill. I've never read it. So that puts me on a level playing field with our elected representatives who have brought us this legislation. And I wanted to tell you that this is, we've heard about cases like the Plessy versus Ferguson, the horrible decision by the U.S. Supreme Court in 1898 or whatever, where they affirmed the concept of separate but equal, and the Dred Scott case where the Supreme Court upheld the fugitive slave law. And I think the courageous decision in Brown versus Board of Education where Plessy versus Ferguson was overruled. This is the type of case we've got right here, folks. This is one of the biggest cases in history of our country. There is so much riding on this case, and if it is found to be constitutional, it is going to be a major step towards fundamentally changing our entire economic system. The system that has resulted in this being the greatest country in the world is going to be, in my view, substantially impacted in a negative way if this legislation is found to be constitutional. Now, when I came here today, it seemed as though there were several people in this room that I heard talking who might be more qualified than me to give this presentation. And I'm going to try to give you some just a basic overview about what the issues are in the case. There's basically 4 big issues. The Fourth Circuit Court of Appeals, which is the Court of Appeals that covers North Carolina, they ducked the question, and they didn't rule on whether the statute was unconstitutional because they wrote something called the Anti-Injunction Act, I think of 1877, which basically says that they concluded this was an illegal tax on the individual mandate. If you don't buy insurance, you have to pay a penalty. The Fourth Circuit concluded that that really was a tax, and under this anti-injunction statute, the case was not right to be considered until somebody actually had refused to buy the insurance and pay the penalty. The second issue, which is the biggest issue, is the individual mandate. Under the individual mandate, individuals must buy insurance to provide minimal essential coverage, and if they don't, they have to pay a penalty. The third issue is the question of severability. This is a lawyer thing that many of you may not understand or think, this is kind of a bizarre concept, but the issue under severability is if the court finds some provision of the statute to be unconstitutional, does that make the entire statute unconstitutional? Or can they just take out the unconstitutional part and let the rest of it stand? The final issue is the expansion of Medicaid. Bill, I hope, will be able to give more nuance or detail to the whole Medicaid program, but as I understand it, Medicaid has been like an expanding monster for many, many years, and the way they build Medicaid up is the states can take money to help pay for medical costs for people who are eligible for welfare programs, such as aid to families with dependent children, things such as this. The states had the option to opt out. If they didn't want to, they didn't have to take the money if they didn't want to cover the folks involved. And now under this statute, they're expanding Medicaid, and if you don't agree to take the expanded coverage to a far broader group of people than what Medicaid has covered before, then you stand to lose all the other money that you're getting for Medicaid for the defined specified groups. So the argument that several states are making is that this is going over the top. Congress certainly can make some reasonable conditions on providing federal money, but this is just nothing like that. This is unprecedented. This is so coercive. It's got to be beyond the authority of Congress to make this drastic condition on the states accepting Medicaid. Now, what are the constitutional issues involved? Well, first of all, I want to steal a line from Bobby Knight. I don't know if you ever saw him do this once, but at a press conference, he was always mad at the NCAA, so he walked in one time and he had all the NCAA regulations on recruits and whatever. It was a stack of papers this big, and he threw that down on a table, and then he pulled out this document, which I'm going to pull out. This is the United States Constitution. Now, the Obamacare law has probably got more stacks of paper in it, and they haven't written the regulations yet, than the NCAA regulations on recruits. Between the Obamacare law and the U.S. Constitution, which one of these do y'all think is the better written document? So what's at stake? Well, first of all, Article 1, Section 8 deals with the authority of Congress to regulate interstate commerce. And I believe if we went back and did an honest, objective history on this, we determined that what this was really designed to stop was states putting tariffs on other states' merchandise, preventing states from printing their own money. This is what most of the founders thought was meant by that. Now, there are some of the founders that had a more expansive notion of that, such as Alexander Hamilton. Some of you who study history, you may recall, he was a big proponent of the National Bank of the United States. Well, a lot of the founders didn't think that was authorized by the Constitution. And at the end of the day, Hamilton kind of got his way, and then when the New Deal came around, the traditional limits that people had thought applied to the Commerce Clause were pretty much thrown out the window. So Congress and lots of legal scholars think that the Congress can do just about whatever they want to in the area of social legislation, economic legislation, because of this expansive notion of the Commerce Clause. One problem that I think they have with that sort of interpretation is the 10th Amendment. Yeah, the 10th Amendment says the powers not delegated to the United States by the Constitution nor prohibited by the states are reserved to the states respectively, which means they're reserved to each individual state and to the people. So there's a conflict here that's been brewing. That's the 10th Amendment proponents have not done so well in the last 50 or 60 years. But this case is really setting up the conflict between these two provisions more dramatically than ever before. And quite frankly, as some of the justices have said, if you follow the arguments, what is left of any prohibition for Congress to do whatever they want to if this particular legislation is not constitutional? There's two other parts of the Constitution that I think come into play. One is in Article 1, Section 10, which says that the states shall not enter into any laws to impair the obligation of contract. Now, it says the state should not do that. I think that the reason why it was written the way it was is because the Farmers knew that the federal government had no authority to impair the rights of contract. Making someone buy health insurance is certainly impairing with an individual's right to make contracts. And furthermore, in my opinion, it violates the First Amendment, the freedom of association protections we have, the right to associate with whoever we want to associate with. Forcing me to buy insurance is taking away my choice for who I wish to associate with on a matter such as health insurance or on any other types of matters so that I may want to decide who I want to give my business to. Briefly, I want to go through what I think is going on with the various points of the law. I think the court is not going to duck the question by using the anti-injunction law. Judges like to avoid making hard decisions, and I think the Fourth Circuit used the anti-injunction law because they didn't want to be the ones to make a decision on this statute. The anti-injunction law only applies to taxes. It doesn't apply to penalties. Almost everyone agrees that the sanction for not buying insurance is a penalty, it's not a tax. And I even understand that the Solicitor General, who's the member of the Attorney General staff who argues cases in the Supreme Court, he's agreed that this is a penalty and not a tax. So I don't think the court's going to adopt the issue. Individual mandate. Something like this has never been done before by Congress, where they're ordering American citizens to buy a product or a service for a good reason. Let me give you an example of something that is not implausible if this statute is found to be constitutional. Remember the old saying about what's good for GM is good for the United States? Y'all, any of you old enough here like me to remember that? I think it was one of Roosevelt's cabinet members or whatever, but let's say we come back to whatever is good for GM is good for the United States. GM was bailed out by the federal government. Some of the biggest political supporters for the president, the United Auto Workers, got a significant share of the membership on the GM board as a result of this bailout. Now, what if the Congress suddenly decided, you know, I think it's good for everyone to own a Chevy Volt. So we're going to pass a law requiring that everyone buy a Chevy Volt because all these good things are going to result from everyone owning Chevy Volts. What does prevent the Congress from passing a law like that if it's okay for them to pass a law requiring that you buy health insurance or pay a penalty? You buy a Chevy Volt or you pay a penalty. How's it any different? In the arguments yesterday, I know that Justice Scalia made the comment, well, is Congress going to make us all buy broccoli now? That would be good if we all ate broccoli. And I think Justice Roberts said, what if the Congress said we all had to have cell phones because it was important for everyone to have a cell phone in case there was an emergency and we had to reach this person? So what the individual mandate does is completely unprecedented. And as Justice Kennedy said, it fundamentally changes the relationship between the government and individuals in this country. That is fundamentally in conflict with all the principles that the country is founded upon. And in my view, it should be held unconstitutional. Maybe I'll get time to comment later about whether I think it will be or not. But it definitely, in my view, should be held unconstitutional.
Don't keep us in suspense.
Yeah.
Well, guess what? I don't have a vote. Severability. Again, severability is a concept that judges use, good judges who believe in judicial restraint have traditionally used this concept to take out of a statute the unconstitutional provision, provided the rest of the statute to go ahead and be enforced as Congress intended. I'll give you my opinion on this one. I don't know how in the world they can find the individual mandate to be severable for several reasons. First of all, I don't know if you remember the dubious procedures that were followed when this plan was enacted, and our inspector becoming a Democrat and voting to be the 60th vote to break the filibuster in the Senate. Prior to going to the Senate, The House had passed a version of this bill that had a severability clause in it. Possibly because the insurance companies, the big insurance companies, who are one of the beneficiaries of this law, would not support the law unless there was the individual mandate. Because they think the law would drive them into bankruptcy with an individual mandate. I don't know if that was the reason or other reasons, but when the Senate got the bill, the Senate took out the severability clause. And then in order to avoid another filibuster in the Senate, instead of having a conference committee where the two bodies worked out their differences, the House had to accept the bill exactly as the Senate had passed it. That's the way they got around the potential for another filibuster on the bill. So most statutes where the courts find a bad provision to be severable have a severability clause. Here, the Senate intentionally took out the severability clause. So that's point number one. Point number two, the whole thing falls apart without the individual mandate. They can't pay for all this stuff. I don't think they'll be able to pay for it all anyway. I don't trust the projections of it. But everybody who supported, every industry who supported the bill believes that you cannot pay for all these new coverages and expansions of rights without the individual mandate. So in my opinion, the individual mandate should be ruled unconstitutional, and I do not see how the court can principally sever that from the rest of the statute. The final part of it, which frankly is somewhat befuddling to me, is the Medicare or Medicaid expansion. And again, the history of Medicaid is back when healthcare costs were a lower part of the gross domestic product than we have today. We started getting the federal government involved in the medical field, and it ratcheted up as they made more and more money available under Medicaid, and they targeted the new bunches of cash that were going to be made available to states to specific groups who were also receiving benefit under some other program. Now, they're not going to do that anymore. You're going to have this universal coverage, and the states can still opt out, but if they opt out, they lose all their other Medicaid money. So what we have here, I'll say something for my college I went to, Hillsdale College. We never accepted any federal money, ever, since 1844. We don't have to worry about the government pulling fast on us like they're doing in the states. The states have become dependent on this federal money, and now, as they are dependent on it, the Congress is putting a squeeze on them and saying, you've got to go ahead and expand this coverage, or you're going to lose all this other money we're giving you. And the costs are going to be substantial to the states. I believe I read that Medicaid for the states currently constitutes over 20% of all budgets for all states. And I think I read that the expanded coverage is going to cost $22 billion from 2014 to 2016 or 2018 for the care part, and another $11 billion for administrative costs. So what this is going to do to the states if they opt in is uncertain. What it's going to do to them if they opt out is going to ruin the programs that you have for providing medical care for people who are currently covered by Medicaid. One comment out of oral argument. I had the privilege of having an oral argument in front of the Supreme Court. A good friend of mine said that an oral argument in front of the Supreme Court is like a cat playing with a dead mouse, and the lawyer is the dead mouse. So the judges are batting the dead mouse back and forth, and what they're trying to do with the questions they're asking, they're pretty much trying to get whoever might be on the fence to go along with their position. My bet is there's 3 or 4 of them on both sides that have their minds made up. There's 1 or 2 that might have an open mind about this. So each side's trying to use the lawyers to convince the judges sitting in the middle to go their way. I caution you about trying to predict what the court's going to do based upon the comments the judges make, because they have all sorts of ulterior reasons for making comments they make in oral argument. I've seen and been a part of an oral argument where the judge just, ripped me a new one with all the questions he asked me, and then he ruled my way when he issued his opinion. I've had other cases where the judge was sweet as punch at me and went against me when he issued his opinion. And I've seen this in the Supreme Court cases also. If you want to know the way I handicap what's going to happen, I think those that oppose, those in favor of Obamacare have got 4 very strong votes in favor of it. Those 4 justices will almost always find a way to uphold social legislation passed by a Democrat-controlled Congress and supported by a Democrat president. On the other side, it's not so sure. And the reason why it's not so sure is because the other 5 justices each has their own principled view of judicial review, which includes the idea of judicial restraint and deferring to the Congress. So I would have to say I'm more optimistic, maybe this is wishful thinking, that this law may be declared unconstitutional based upon comments at the oral argument. But if it's going to be unconstitutional, it's going to be a 5-4 decision, which again, as we just seen, most of you call it Supreme Court cases. We kind of have a 5-4 majority on the Supreme Court, and if we lost that all of a sudden, the next issue would be there would be nothing left to restrain the Supreme Court what they can do. And it just shows you how important it is to get good judges who understand the Constitution, understand our traditional values, and understand the concept of judicial restraint on the court. So maybe we've gone over, but
we'll forgive you.
right now.
Well, thank you for that.